Al Dassinger, Civil Justice Association of California. We oppose.
Thank you. Other individuals, witnesses in opposition? Bring it to the members. Any questions? Senator Wojtkowski?
All right, so I've listened to the opposition. Normally, spouse dies. If the surviving spouse sends a check in, is it the practice of the banks and the mortgagee to cash the check on the loan? Even though I'm not a signatory, but I send in the check. Let's say there's no problem. So I'm not asking to assume the loan. I'm just sending in the money. They cash the check, right? Is there anything against the law that allows them? I can't believe they wouldn't cash the check, but I still have to ask the question.
So Ms. Stokes from the Legal Services of Northern California shared one of her clients' experiences. And in that letter, she mentioned that she was making monthly payments until she could no longer. And that's when she tried to contact the servicer to see if there was the possibility for loan modification, but couldn't even make contact.
Because one of the criticisms is that this is the delay in the proceeding. And if the facts are that the spouse, surviving spouse who's on title, which I think is a significant difference from just heirs in a probate estate. I mean, nobody's going to, again, I would imagine the personal representative in the probate estate has a responsibility to protect the assets and would send in a check that says I'm the, a representative for the probate estate. I don't know how that would not happen, I guess, unless she didn't probate the matter. But that's going to be resolved by that court. That court's going to say who's the heir. Because it seems to me there's some people who will make payments and then, as you indicated, they'll fall out. They have during that time, there's no other claimants. There's just one person on the title, and the mortgagee is not compromised, maybe not hurt financially, while they're accepting those payments. I guess I'm trying to make a distinction between the people that make a payment, then their economic situation falters, and then they have to seek a loan modification. How is that fundamentally different from the original applicant, right? Other than, I mean, everybody is at risk of having their financial circumstances change. So whatever they contracted for is compromised, right? I mean, we all have we could lose this, I could lose the election, right? I guess that would happen here. So I see a fundamental difference between somebody who's on title and is seeking to step into the shoes of that debt versus just a random person that has a claim on it. Am I missing the point here? Because I would think that all the random successors, the multiple successors, would be part of the probate. I mean, that would ultimately get resolved by the probate court.
I think that is absolutely correct. The vast majority of cases that have come to us and to other entities to testify, first of all, involve surviving spouses, frequently widows, who have already been on title as joint owners with right of survivorship. That's more frequently the case. Sometimes the spouse knows right up front, though, the survivor knows right up front that they have a financial problem, that losing that loved one's income is going to making these payments moving forward after having paid for funeral expenses and whatever else happens as part of the death of the loved one. They know that early on, hey, I need to have some guidance here, mortgage servicer, what do I do? Do I have any options for adjusting my payment? So sometimes actually that point in time will come sooner rather than later, but they're already on title.
Right, and that's because the mortgagees and like the county assessor or the tax people, they have obligations, they have debt, they have a responsibility to check the title in the counties to see who's transferred some ownership. You can impair that or dilute that ownership. Doesn't impair your contract, right? But they're on notice when that person recorded the title, the change of title, right? I mean, they went in and said, okay, now I'm going to add my wife to this or add my husband. So they have notice. It's not a big surprise, it shouldn't be a surprise, not that they're down at the recorder's office looking to see who does the transfer, but that's their business, right?
And usually the survivor, sir, also promptly makes contact saying this has just happened and reaches out for help. So they're not notification sooner rather than later, usually.
So the opposition brought up the freedom of contract and said that, your presentation, Senator Leno, was that you're not creating any new programs here. They're not supposed to approve loan modifications if they don't qualify. You just want them to step into the shoes
Correct.
of the mortgagor, right? The mortgagor at the beginning. How would you respond to the freedom of contract that the debt on this property, large or small, is the deceased person's debt, and the bank mortgagee never negotiated with this third party that's actually has an ownership interest? How do we balance the ownership interest with the debt obligation?
So the only requirement that the servicer must allow the successor in interest to assume the mortgage is if the mortgage is originally assumable under the terms of the contract and the applicable laws and regulations. So we can't change that, and we wouldn't pretend that we could.
Okay.
Senator Mourning.
Thank you, Madam Chair. So from the supporters' testimony, we hear of some pretty horrific cases, people dealing with a loss of a loved one, a spouse usually, and then combined with facing reduced income, and a lot of this convergence at the time of the Great Recession and a continuing recovery. And then from the opponents, we hear, well, there's really not a problem. So I find that to be out of touch and at least non-responsive to a problem that's been clearly framed. So I would have appreciated a little more sensitivity to the impact of the problem created. But the opponents did raise, and I direct this to the author, in-process federal regulations addressing this. And I'd just like to give you an opportunity to respond to that. They seem to suggest because that is in the pipeline, this bill isn't necessary, or this bill could create conflicting rules and laws. So just like to hear your response to that.
We are prepared, excuse me, to amend the bill, and clearly not in committee today, but as it goes to the floor, to amend it so that it would align with any future Consumer Financial Protection Bureau regulations.
Thank you. Madam Chair, at the appropriate time, I'm prepared to move the bill.
Very good. Is any other questions, Senator Morlock?
I know that the facts of each case are completely different, but I'm just curious, factors like life insurance proceeds, mortgage insurance proceeds, or even a reverse mortgage, were any of those options pursued by those that contacted you for this bill?
Yes, Senator. So most notably, most of the Central Valley, all the way down through Kern County, Imperial, Riverside, San Bernardino is still underwater. You can't get a reverse mortgage unless you have significant equity in the property. For those of our client, and you have to be a minimum of 62 years of age. Age is not usually the problem that we've seen. It's the lack of sufficient equity to actually qualify for a reverse mortgage. But we always offer that as, we explain what that is to the survivor and offer that as an option for the person to consider.
Yeah, and I didn't have all the facts in the case. I don't have ages, I don't have equity, I don't have all that, so that's why I'm just a little curious. So it would seem that if a bank was notified, they would have a customer service department jump on this. And I'm just wondering if one of the witnesses could just respond to that. Just
Thank you, Senator. Not understanding all the facts that have been presented on some of the individual circumstances, it is the case that mortgage servicers have to have policies and procedures in place to communicate and to help the potential successor in interest understand what kind of documentation they may need to demonstrate the death of the obligor. That's fairly straightforward, typically accomplished by way of a death certificate. And then demonstrate that they have an interest in the property. Sometimes that's a little bit more complicated if something's going through probate. The mortgage servicer then helps the successor understand what their options may be. And in some cases, that may be that they can simply continue to make payments. They don't have to accept the underlying debt if they fit within the Garn-St. Germain rules. They may be entitled to a loan modification. That has to fall within the parameters and the requirements. So first they have to qualify for a trial modification, and assuming they can perform, they get converted to a permanent modification. Only until they can demonstrate that are they then allowed to consider assuming the mortgage, because you want to make sure that they can succeed. Or you simply just allow them to assume the mortgage if they can make the payments under the existing terms and conditions. So, you know, there have been policies and procedures put in place. I think we would agree, and we even presented to Senator Leno what we thought was a bridge solution. From our vantage point, we could all do better communicating with one another. And we propose that while the CFPB is taking action, that we would be willing to see in statute a bill that addresses the piece about communication, because we've heard that loud and clear. We've understood that we could communicate better. So we proposed that in the circumstances where you've got a surviving spouse or a child who wishes to stay in the home, that we would be willing to deal with that universe. That has been the examples that have been brought forward. That's been the testimony that's been provided. We would be willing to do that on a limited basis to make sure that that individual has sufficient information so that they know whether the loan is in arrears and how much they would need to make in payment on a monthly basis. We would suggest that there be some other penalty other than a private right of action, but at this particular point in time, we don't think that the senator is inclined to accept our offer to deal with the communication piece as a bridge while we wait for CFPB action.
So not to bash anyone in your industry, but the name Citibank was raised. Do they just have trouble being a good customer service bank? And I just say that because I was a chairman of a credit counseling nonprofit many moons ago, and it just seemed like, so I want to make sure that one banking institution isn't representative of everyone, that all the, maybe, you know, and I'm picking on one, I'm sure I'll get a call tomorrow, but I want to make sure that this is an issue that is unique, that the witnesses were unique cases, not something that happens all the time. I just want you to reassure me that I should.
Senator, we're proud of the member banks that we represent. What I would say to you is that these are complicated situations, particularly when you're dealing with somebody, you know, who's passed away and you're trying to figure out how to manage the assets. So these are complicated fact patterns that could involve multiple individuals who may have an interest in the property.
Madam Chair,
Yes,
could our co-sponsor briefly respond?
briefly, and then if there are no other questions, I was going to ask you to close. So very,
Stop there then, Madam.
okay, good. Very brief, and then if you would close, Senator Leno.
Very briefly, so we had actually put together a list of just from our own cases and provided it to the committee members in previous committee. I'm happy to share the same thing, but there are many other names that pop up on that list. Chase makes frequent appearances. Wells Fargo is there. B of A is there. Bayview Loan Servicing. And these are cases from all around California. It's quite significant. So it's, alas, it's more than just one particular entity.
So Senator Leno, if you would like to close.
Sir, very briefly, thank you for the committee's time. Thank you for the fine analysis and the recommended amendment, which we've taken. Also to reiterate my commitment to amending the bill on the floor so that it will align with any future CFPB regulations. So that should just take care of that issue altogether. And then lastly, to thank my joint author on the bill, Senator Kathleen Galgiani. And the reason she has proactively stepped forward to ask to be a joint author is because she is living and breathing this every day in her district, which is still underwater and has horror stories that she can recount by memory. So I would ask for your aye vote.
Thank you very much. The motion, is there a motion? So moved. Oh, Senator Mourning has already moved it. The motion is do pass as amended to the Senate floor. Please call the roll.
Jackson?
Aye.
Jackson, aye. Morlock? Anderson? Anderson, no. Hertzberg? Leno? Leno, aye. Monning? Monning, aye. Wachowski?
Aye.
Wachowski, aye.
4-1. I assume the vice chair is abstaining. 4-1, that bill is out. Right. And the final item, I will take up the caboose here with SB 1336. What file item is that? File item 14.
Colleagues, we're considering Senate Bill 1336 with Senator Jackson, and as soon as the pizza arrives, you have the floor.
Good evening, Mr. Chair and colleagues. I bring before you this evening SB 1336. This is a bill with the goal of improving efforts to identify and prioritize relatives for placement of children in foster care, with the intent to reduce the time they spend in foster care and help improve their chances of being reunified with their parents or reach permanency with a relative. This bill does this in two parts. First, it will codify the family finding rule of court, which requires a dependency court judge to make a ruling of whether a county child welfare agency has exercised its due diligence in searching for known relatives when a child is removed from the custody of his or her family due to abuse or neglect. Secondly, it would clarify how and when preferential consideration of relatives is considered by a dependency court in order to ensure that children in foster care are provided every opportunity of being placed with a relative caregiver when it is in their best interests. There is uncontroverted data that shows that placements, generally speaking, with relatives is a very strong positive in a child's, protecting a child, and also in the potential to live a more normal and secure and stable life. That family members do provide that at far greater levels than those who are not family members, and this bill is designed to try to reflect the data and to make sure that children who are in foster care have the very best opportunity to be successful in their lives going forward. With that, I would ask for your aye vote.
Mr. Chairman, members, Ed Howard on behalf of the Children's Advocacy Institute at the University of San Diego School of Law and the Children's Law Center. First, we want to thank the author for bringing forward this important bill that will improve the lives of foster children, abused and neglected children throughout the state. As the analysis correctly points out, consideration of whether or not it is in the best interest of a child to be raised within the arms of their loving family should always be a factor in determining appropriate placement. As the author mentions, this bill simply ensures that that is always the case, that there will always be a situation where whether or not it's in the best interest of an abused and neglected child to be raised with their family is always present in the minds of the judge, and we respectfully ask for your aye vote.
Thank you, Mr. Howell.
Mr. Chair and members, Lexi Howard on behalf of the Juvenile Court Judges of California, a section of the California Judges Association. We support SB 1336 to help enhance and improve how relatives are better identified and considered. Relative placement and engagement early in the process is an urgent matter for children, and fast and quick identification of those relatives reduces the trauma that children ultimately experience in other placements where relative placements are far preferable. We ask for your ayes.
Thank you, Ms. Howard. Are there any other witnesses in support? Witnesses in opposition, if you would just line up, please, and move to the microphone. Okay.
No, there is a witness.
Shoot.
There is a witness.
Okay.
Thank you for allowing me to speak on SB 1336. I am with Advo Kids. My name is Erin Hupp. I'm a staff attorney, and we are a nonprofit committed to foster children in California with a special focus on ages 0 to 3. We are the registered opposition. We support the first half of the bill fully and wholeheartedly, holding child welfare agencies accountable to early location notification and assessment
Ms.
of
Huff,
relatives.
you are welcome to sit down if you want.
Oh, okay.
Sorry.
So as I said, we fully support the first part of the bill, which is about notification, location, and assessment of relatives early on. However, in the second half of the bill in its current form, we're having trouble supporting. So placement changes hurt all children, but particularly very young children who need a consistent, caring, and reciprocal relationship with a caregiver in order for their brain to develop. Children in foster care are at particular risk for attachment disruption. Decisions to move children must reflect their best interests. Since the 1960s, the concept of the best interests of the child has been codified in our state statutes, case law, and child welfare regulations. These laws say that any foster license, foster family agency certification, relative approval, or NRFM approval, non-relative extended family member approval, do not entitle a person to placement. That placement has to be determined with careful judicial consideration of the child's best interests. However, this bill, as it's written, will dilute the decades of these statutes, case law, child welfare, and licensing regulations. The second half of the bill requires that if or when a relative comes forward, only the agency is to decide whether or not that child should be placed with the relative. This bill adds weight to the relative side of the scale without an equal weight to the child's side of the scale. We believe that the child's side of the scale should have equal or greater weight. We believe that in order to protect children from harmful placement changes, both the agency and the court should review all prospective placements carefully with the best interests of the child standard paramount, using the existing criteria in Welfare and Institutions Code 361.3a, which the relative has to pass at the dispositional hearing. We urge you to not pass this bill without protecting children's best interests and making sure that you're keeping protections on the child's side of the scale. Thank you so much.
Thank you, Ms. Huff. Any further witnesses in opposition? Any questions from my colleagues? Senator Wieckowski.
I guess I had for the opposition. I guess the concern is that you have a placement with a foster care.
Please have a seat.
A foster care family, and then family member comes in or is contacted and says, I want to raise this kid. Is there some data that we have? I think, I'm talking off the top of my head, if it's 3 months that they're with the foster care family, and then the family member comes in, that doesn't seem like, I think it's an easy finding that it's in the best interest of the child. If it's 12 years and then the family member comes in, well, that may actually work out better. Is there some data that you're relying on for the shifting of the placement for the kids that you feel is harmful?
So modern neuroscience says any attachment disruption like that, once the child has attached, especially for ages 0 to 3, it causes trauma to the child. But all we're asking is that in the second half of the bill, that there be judicial review. It's not just an agency decision. That means that the judge then goes back to 361.3 subsection A and has the enumerated factors to look at in guiding that decision.
So for toddlers and 4-year-olds and above, it's not so much of a concern. It's just the attachment with the infants, right?
We focus on children, well, 0 to 3, 0 to 5, just because if you imagine their whole lifetime, sometimes we see cases on our hotline that are a 12 or an 18-month-old child and they've been in with that caregiver their whole lifetime, right? So that just the child's sense of time is different than us as adults. And they attach to a primary caregiver, and that attachment is essential for their neurological function. Neuroscience, modern neuroscience has proven what we've first thought of in the best interests of the child, 1960s book. And so all that we're asking is that there is careful judicial consideration of the child's best interests, and we're suggesting that you go back to 361.3A as a guide for the judge to look through when determining whether this move, this change in placement is in the child's best interests. We fully applaud the first section of this bill.
I'm only worried about the second section.
Okay.
So, Senator Jackson?
Actually does call for judicial review, so I'm a little confused. The bill doesn't exempt the county or the court from any of its current authority, nor does it require a county or court to make a placement. It brings it to the court's attention. The court is then required to consider, because there is that presumption that it's not an unequivocal presumption, but there is a presumption that it is in the best interest of a child to be in the care and custody of a relative. And the court does have the authority to, it has the discretion, but it is directed to consider these factors. So I would have to respectfully disagree that we are taking away this discretion from the court. Absolutely not, as I read the bill.
Just to add, Senator, that's exactly right. There's nothing in the bill that changes that it is ultimately the court's responsibility to determine what the proper disposition and placement of the child is. And if you look at the actual bill language, you'll see that those references to the court having final disposition authority are not changed.
Well, if you would like an answer from her, I'm fine with that. Ms. Huff, please.
Okay.
You have the
So
floor.
I think you're discussing the dispositional hearing, is that correct? And I'm talking about later in the case, post-disposition, making sure that in the bill there's a reference back to 361.3A, which is a section that is referenced to the dispositional hearing, which is one of the first hearings in a juvenile court process child welfare proceeding. And we're saying later on, when the child has been placed in a concurrent planning home, that the court be directed to go back to those criteria that are in 361.3A that the legislature passed, and just go back and review them and decide whether it's in the child's best interest to make that placement change post-disposition.
That answer your question, Senator? You're doing good. Any more questions? Anyone else? Well, Senator Jackson, would you like to close?
Yes, thank you. We've been working with CWDA. They could not be here at this late hour. We are working with them. We are trying to come to, there's still parts of this bill that need to be worked out. We're continuing to work with them. But we think this is really an important step forward in trying to deal with what we know, again, to be, generally speaking, in the child's best interest. The court continues to have the ultimate jurisdiction. We really want to encourage, the goal is to encourage at the earliest possible time, identifying potential family members who can provide the care for our foster children while they are going through what is a very, very difficult time, and place them in a family setting to the extent possible. That's essentially what we're trying to accomplish with this bill, and we will continue to work toward that end with the stakeholders going forward to achieve it. That is, nobody wants to upset the apple cart. We're just trying to fix a very serious problem that exists and try to do it in a way that will be in the best interest of the child and do it as quickly as possible during the early stages of these proceedings. So with that, I would ask for your aye vote.
Senator Jackson, I'm assuming that your office is working with Ms. Huff and open to more suggestions, or?
Well, we certainly will. At this point, we disagree with their analysis of the law, but that's what, certainly we can continue those conversations.
Okay. Do I have a motion? Very good. Madam Secretary, please call the roll.
The motion is due pass and refer to the Senate Rules Committee. Jackson? Aye. Jackson, aye. Morlock?
Aye.
Morlock, aye. Anderson? Aye. Anderson, aye. Hertzberg? Leno? Aye. Leno, aye. Monning? Aye. Monning, aye. Wachowski? Aye. Wachowski, aye.
Passes 6-0. That is out. So did you want to adjourn, or can I? Oh, that's right. You're right. You're right. You're right. Thank you.
What we're going to do is we're going to go through the roll. If you have been here the whole time and you voted, have a nice evening. Thank you for being here. Let's call the roll on all the items for which there is the roll is open. All right. The consent calendar, please call the absent members.
Hertzberg? Wachowski?
Aye.
Wachowski, aye.
All right, 6-0, the consent calendar is adopted. File item 7.
We pulled
It was pulled. Thank you. File item 7. The vote count is 5-0. Please call the absent members.
Hertzberg? Leno? Aye. Leno, aye.
6-0, that bill is out. File item 12. The vote count is 2 ayes, 3 noes. The chair voting no. Please call the absent members.
Hertzberg? Leno? No. Leno, no.
That vote fails. Reconsideration is granted. File item 17. The vote count is 5-0. Please call the absent members.
Hertzberg? Leno? Aye. Leno, aye.
6-0, that bill is out. And that concludes our hearing today. Staff, great job. I want to thank you all for very fine work you did today. We are adjourned.